of December, or do we just go forward from there?
We don't usually
I
approve
didn't,
the
I
minutes.
didn't think we did for subcommittees, but I wanted to make sure. Very well. Okay. I think back in January, Nicole sent out kind of an updated status of the opinion or opinions started by this inquiry of Adams, who is a prosecutor. And I think we pretty much are close, I think, to finalizing what we have. But I wanted to kind of go through, if it's okay with you, Nicole, and kind of go through each inquiry in the following subsequent opinion and kind of open it up again for comments or concerns from the members of the subcommittee, if that's okay.
Okay, that's fine. Do you want me to summarize each
Yes, ma'am.
one?
That's fine. Just go through one. Let's go through them one at a time, and then we'll pause and see where we are.
Okay. So this is the inquiry about a lawyer limiting their representation to just a bond hearing when the defendant has qualified as indigent and has appointed counsel. So the first inquiry is about Rule 4.2, and the question is whether or not a lawyer who knows that a defendant is represented by counsel can meet with the defendant for purposes of either a second opinion or talking about discussing taking on representation. And there's an exception under Rule 4.2 that allows a lawyer to meet with a represented person for purposes of discussing representation. So that's what opinion number one concludes, that it's fine for the lawyer to meet with a defendant to discuss representation, even though there's appointed counsel.
Okay. Any questions or concerns about inquiry one and opinion one? I don't think we really changed much of this the last time we met, but I just wanted to make sure. Okay, then let's move on to inquiry number two and opinion two then, because there are some changes there.
Yes, so inquiry number two asks whether or not the lawyer may limit representation and undertake representation knowing defendant has appointed counsel. And the opinion is that as long as the lawyer is following Rule 1.2 on limiting representation, which requires that the limitation be reasonable under the circumstances, and the defendant has to consent after the lawyer has explained the ramifications of limited representation, what that could mean to the defendant's indigent status, and whether or not they would still qualify as indigent status and have appointed counsel to handle the remainder of the matter. At the last committee meeting, we talked about discovery and added some additional language that said at the earliest time possible, the lawyer or the retained lawyer needs to look at the client's case, look at any available discovery, and educate himself or herself about the status of the case. We added a footnote that the lawyer should endeavor to involve appointed counsel to make sure that whatever strategies that the retained lawyer is taking, it's not going to have an adverse impact on the client's overall criminal matter. The rules don't allow us to say that the lawyer must communicate with indigent counsel, but there is a strong suggestion that the lawyer should do that just to protect the client's interests.
Okay. And for the sake of the subcommittee members, I emailed Nicole just a few minutes ago, and I'm going to kind of defer in this respect to both you, Nicole, and to Brian. The concern I had, and it's not really a concern, I just want to make sure we're okay with using this language, is the very last sentence of the third paragraph. It appears on the second page of the inquiry itself, where it says, failing to communicate lawyers' involvement with appointed counsel under these circumstances would be prejudicial to the administration of justice. I went and looked at the rule and the comments, and I guess the concern I have that kind of set off a little bit of a red flag, not much of one, was this language would be. Should we?
I actually changed that. I'm sorry, I didn't mention that. When I was reading it this morning, I realized that it should be might be prejudicial.
Okay.
Because it will depend on the circumstances. So we shouldn't have a sentence that determines that it is prejudicial to the administration of justice, because we don't know.
Okay.
So I changed would to might.
There you go. That's fine. Perfect. Okay. Thank you for that. Assuaged my fears. Any other comments? I like the additional language you use, the rephrasing of some of it from our discussion in January or whenever it was we last discussed this.
December.
Okay, December. Wow. What about you guys? Anybody else on the committee chiming in on that issue? Okay.
I think the changes capture what we talked about.
Okay. What about, again, I'm not trying to belabor this meeting. What about inquiry 3 and opinion 3 as modified or kind of developed from our meeting in December? Yeah, Bert's got his hand.
You're on mute, Bert.
I spoke to Nicole this morning about this to sort of think out loud. The way 3 is written, I think it probably needs to be just taken out because it becomes moot. I mean, once the matter is resolved, there's really no need to withdraw in a specific bond hearing type situation. So client's family comes in there, hires somebody, they get the consent from the defendant, which typically takes somewhere between a second or two, or a letter from the jail, because there typically will be in jail. Right. And then, and candidly, there could be a ladder representation that goes on without the defendant even knowing about it until they're released, or until the bail bondsman comes and says that their bond's been made. But I think there should be some type of consent, because everything happens. I understand what you're saying, and I agree. I think the defendant should consent, but 99.99% of the time, a defendant's whole goal is typically to get out of jail. So they'll consent to anything to get out of jail. And so that's probably the reason why that if it does go on, and I'm only speculating that it goes on, it never reaches a point to where a defendant contacts the bar and says, I didn't consent to this. Well, typically it's because they're getting out. And so they're just happy to get out. And I'm just being practical, Friday afternoon, Saturday afternoon type of practice. But the third one, dealing with the bond hearing. I mean, once the bond hearing occurs, typically the limited representation stops and is resolved, unless the bond hearing happens to get continued to next week, or it's a continuing bond where they pay somebody $500, they get it knocked down, $250,000 from 500 to 250, and then there's maybe another attempt. But typically it's one shot and that's it. Now, on the flip side, I could see limited, someone trying to withdraw from a limited, maybe in district court, especially when something's been in probable cause court, which is our hub for felonies that have not been indicted yet. And it goes on for a year or two, and the individual hasn't finished paying. And so they will make a move to withdraw from the limited representation of district court. So those are the only two times, not to beat this horse, but those are the only 2 times I see limited representation. I have never seen in this area some type of limited representation up in Superior Court, where it's just like I'm limiting only to a plea arrangement and sentencing. I'm not. It's typically in our district, either in Superior Court or you're out of Superior Court, unless it's a bond hearing. Bond hearings, I have seen it. So that's it. I'm just saying that inquiry number 3 sort of becomes moot once it's been resolved. So
Bert, can I ask a question?
Yeah.
This is my ignorance of criminal practice. You know how we have like for civil cases, there's Rule 16 in the general rules of practice for superior and district courts that basically says an attorney, once their attorney of record, can't get out without the court's permission. Is there a similar expectation in criminal practice?
Limited representation typically is not an attorney of record.
Okay.
They will, especially if, it's not attorney of record. It's not attorney of record in indigent cases because the public defender will always be in it, or the appointed counsel will always be in it, unless it's a general appearance. Now, if it's in a retained case, then yes, I could see them be put into the ACES system or CMS system for representing them.
Okay.
That limited appearance, but typically not in bonds. It would only be in like a district court. I'm only going to represent you in district court, and that's it. And So and typically,
you could have other limited representation circumstances, but since we're focused here on bond, I think Bert is kind of right in that sense that it's rare that an attorney would have to move to withdraw once the bond motion is the matter is settled, because by operation of the rules, they're out.
Right. Okay.
All right. And is that okay? Is that okay, Nicole? Is that okay, Brian, from that perspective? You know, that we not even include inquiry 3 and opinion 3 for that purpose, for that reason?
I think that's fine, because there's a sentence in inquiry in opinion number 4 that says exactly that once the bond is resolved, the representation is over.
Mary, have you got?
So is everybody in agreement? We can delete it. Okay.
Okay. All right. Sounds good. All right. And now that brings us to what is on the paper as a inquiry 4, which now would be 3 again. Any corrections or discussions with respect to that? Or Mary, did you have something? I'm sorry.
Me?
Yes. Did you have something?
No.
Okay.
I'm only working on one screen here, so I'm just trying to flip back and forth to look at the text and then come back to the meeting. So sorry if I'm looking confused, but
no worries at all. No worries at all. Thank you. All right. Anything? Go ahead.
As a chief public defender, Mary, I will support you getting a second screen for your job. I will send that email to the appropriate people. And I think
I have 3 in my office, but I'm actually at home today because it was an all Zoom day. So I had to have some work done on my house, and I figured I could multitask, but I only have the one screen. So this is why I prefer my office.
I do have one last question. Nicole, does this answer Adam's inquiry? Or was Adam focused with district court, or was she focused with superior court?
There was no distinction.
Okay.
And so at our last subcommittee meeting, we talked about whether or not there was any distinction between felonies and misdemeanors. And that wasn't part of the original question either. So the inquiry definitely does answer her question. Her question was, can she limit, or can a defense lawyer limit their representation to just the bond hearing when the person has qualified as indigent and has appointed counsel?
Well, before we disband, Mr. Chair, I just want to talk this through, because we got so many talented people on this group and this is really going to be focused to Mary, because Mary has seen such a broad range. Are there cases in superior court where there is limited representation made by an attorney other than bond hearings?
Not that I can think of off the top of my head, right? District court, yeah, but
Okay.
I have seen.
But people are very creative, Bert.
I have seen attorneys in superior court limit representation like through, and I don't know if this really could, I've seen it. I don't know if it's necessarily the right thing or the right way to handle this, through plea negotiations.
See that?
Right. Yeah, and I'm sitting here thinking, how can you do that? But I guess theoretically, you could see that it could happen. Although in my time doing this position, I can probably say I've counted on one hand the times I've seen things like that. So it's going to really be, and for your benefit, Jamie Adams, who I know very well, these cases started in district court and were moving towards superior court in a quick fashion. And she was having these attorneys come from out of district, and trying to get in and get these bond hearings done without really limiting their representation officially. So, so and I think having not really discussed the contents of this with her, I'm basically, because she's plugging me every time we see each other, what's happening. And I say, well, look, we're getting there. I think she'll be satisfied with the result that she can now, at a minimum, hold something up to a judge and say, hey, this is what it's supposed to look like. Right. And not just willy nilly allow the law of the West to basically rule during these circumstances. So, okay.
And Nicole, this is just ignorance on my part. Once this goes through publication and all that, will there be a time when the district court judges and the chiefs will be briefed or schooled on the new?
Not generally. We publish it on our website and in the journal. And so maybe if a judge reviews it and comments, but otherwise, once the full council adopts the opinion, it's just put on our website and later added to the book for new publication. But we don't generally send the opinions to the court.
I will say this, that there is probably enough interest in the prosecutor's area, the district attorney's conference, that you may see a blog post from, Jeff Welty, Shay, those folks at the Institute of Government about this issue in order to educate the stakeholders with respect to this issue. So I expect once if it's official, adopted, that there will be some impact in that area as well. So,
thank you.
And I guess, Brian, it sounds like we're all kind of on the same page. We're all to the point now. I think we want to submit this to the full committee to be then published. So what's our role here? Do we kind of just, or Nicole, you can answer this, either one, doesn't matter. Where do we go from here?
Well, I think if you guys are done with your review, and I had in here is inquiry number 5. Is that you guys?
Oh, I'm sorry. We need to talk about inquiry number 5 before we get to inquiry number 5. Tom, do you remember you sent me an email that you thought in inquiry number or opinion number 4 that sentence that starts with generally a lawyer should not accept representation in a matter unless it can be performed competently, promptly, without conflict of interest, and to completion, should be moved up to the second sentence so that there's an understanding from the outset that the limitation must be reasonable under the circumstances. So that's the first hurdle that the lawyer must overcome. And then think about whether or not they're going to be able to complete the representation as asked based on circumstances. So that they should be talking about to either the defendant or the family, do you have all the money to pay me now, pay me a flat fee or whatever now, or, just have a conversation about if you can't pay my fee, then you shouldn't be taking on the representation, and they should do that at the beginning.
So if I understand what you're asking, should that question that you have underlined, or the statement you have underlined, be moved up and become the second sentence?
Yes.
Okay. I think that probably actually makes a little more sense with the way the opinion flows, that if that were the second sentence, then the next question deals with, okay, if you get there, then, then what happens? And so I'm okay with switching it. I don't really think it takes anything or adds anything one way or the other. What do you guys think? You okay with switching it to the second sentence, Bert? Robin? She's okay. Takia?
Okay,
Okay, very well.
okay. I'll move that and then just make sure that it's coherent and makes sense with the rest of the paragraph.
And,
And I
and we're
think-
still, we're still in number 3, correct? Or the new number 3, old number 4?
Yes, that's
Correct.
correct.
Nicole, is there a way, every inquiry question, but this one, there's a 1-word answer at the very beginning? Is there any way we can be consistent with the 1 word, whether it's yes, no, maybe, depends? It's just OCD on my part. At the very beginning. But anyway,
Well,
just if it doesn't work, it doesn't work. But I know lawyers love to see those 1 word, is it going to be good, bad, or otherwise? I
Yeah,
just didn't know if you could
I
say.
feel like this is it depends.
yeah, yes or no wouldn't
Yeah.
fit here.
Right.
I would suggest we do. It depends.
Okay,
Just, they see it real quick,
Mhm.
and then it will prompt them to continue reading. I don't know. Maybe it's just me always wanting to know my test score as soon as I turn in my exam. So it could be something for my childhood.
I think it's appropriate. I was actually looking at so there's an addition in opinion number 4, what will now be 3, that starts with prior to seeking the court's permission to withdraw, based upon the discussion of the prior inquiry and opinion that will be deleted now. Does that need to be modified as far as seeking the court's permission to withdraw? Because I know there's that statute in 15A that essentially says that once your time is done, if it's this limited scope, you can just step away. You don't have to ask. Are we presuming that the attorney must seek the court's permission when that's an incorrect presumption?
I don't have a problem with it, because I think that unless what you paid for has been resolved in a bond hearing, then it's moot. But if you've limited to district court, and district court's been going on for 1.5 years, and you've been in it for 6 months and they still haven't paid, I think at that point they need to move to withdraw. But that's just my opinion.
and that part goes with when the lawyer realizes that the family or the defendant can't finish paying the fee.
Yeah, that's a continuation of that particular scenario. Okay,
That's correct.
see what you're saying. Ignore me.
No, that's fine. So we're talking about putting the phrase "it depends" at the beginning of what is now opinion 3. Okay. Everybody okay with that? All right, looks like we're all in agreement. Great. And then last is now will be inquiry 4, and that deals with whether it's felony or misdemeanor. The analysis really doesn't change, right?
Right. The focus here is more on not distinguishing between misdemeanors and felonies, but just focusing on any determining factors that the lawyer should be looking at to determine whether or not the limitation is reasonable under the circumstances. So
Right.
I just put in a few examples of what the lawyer should be thinking about: the punishment level, whether there's multi-level felonies, if it's going to result in significant punishment. I have not, we only have 10 minutes. I've not done criminal law, so I don't know if all of those factors, is that enough? Should I add other examples of factors to consider?
Hey, Tom,
Well-
and Mary, what do you think? The multi-level, should that be multi-class? Or, I mean, I know we have levels for punishment purposes, but, and it's semantics I'm talking about at this point.
I mean, wait, classes of crime and levels of punishment, right? Let me read through it again. The limit. I would say, I mean, it's kind of like the determining factor should be based on the class of charges, class of charges levied against the defendant. Yeah, and then you go on and say the lawyer should also consider
Levels
the
of punishment.
levels of punishment. So that's, yeah, I
Yeah,
think that's right.
correct.
Okay. And then what about that next sentence, Mary? For example, a series of multi-level felonies.
Yeah, it's the multi-level felonies is what I was talking about. So it'd be
I just
I
say
thi-
multiple, right? Or,
Multiple
yeah.
felonies. I think you just say multiple felonies.
yeah.
Yeah.
Okay.
And I think the fact that you've included the totality of the circumstances in there, I think is going to, hey, look, you gotta consider everything and not just limit to the examples that you've drawn here or the things you've talked about. So I think that's well placed. Okay. All right. So we're done with that aspect of it. You said we only had a few minutes left.
Yeah, and I'm
Yes.
going to apologize for that. I gave Nicole a license, but somebody took away her license. I'm looking through the roster. So there's shenanigans going on at the state bar.
I blame Peter.
Yeah.
You're zooming without a license. There's got to be
Right.
something going on there. Okay, so the next step, I guess, Nicole, if you would, let me ask you this: are we going to go present this week?
Yes.
Okay. Right.
We've been waiting on this for long enough. So
Right.
if you all are in agreement, I will clean all of this up and send this out by email to the members of the Ethics Committee and for it to be considered at our Thursday meeting. And so you all need to decide, are you ready to publish? Is it going to be your recommendation to publish this opinion for comment?
I'm seeing a thumbs up by everybody. Takia, you good with that? Mary, you good with that? All right. So yes, the answer to that question is yes, we're ready to publish.
Okay, good.
And then I guess the subcommittee, does it kind of exist in an ethereal state until we either get comments and then go forward or have to rehash this thing out any, or
Right. So
okay,
after we, assuming that the Ethics Committee says, yes, publish, then we wait to see what kind of comments we get.
Okay.
And then based on those comments, Brian and I will take a look at those and determine whether or not we need another subcommittee meeting. But I think before that, Brian, we would have to present the comments to the full committee. And then from there, the committee will decide whether or not this needs to go back to subcommittee for additional consideration, considering the comments.
Yeah, I think one thing that we could all do is, essentially if this goes through for publication, those comments that come in over the next quarter, if there's anything that's, particularly striking, or even just like a small twist, whatever it may be, that it may warrant having a subcommittee meeting to kind of incorporate some sort of non-material change. If there's any sort of material change to the opinion, then it would need to get republished and go through that process again. But if there's just some sort of like very little thing that doesn't really change the substance of the opinion, you could potentially do that, or just at least discuss it before the July meeting. I have to note that, we're talking about publishing this over the summer, and there's going to be judges conferences going on and all that. So to the extent that anybody on this subcommittee has any sort of, way to notify folks, like, you all were talking about before, whether School of Government or what have you, there's an opportunity to get this a little bit more attention, particularly this quarter. So, but yeah, we could basically bring it back to the Ethics Committee in July, see if we don't receive any sort of negative comments, that it could just be pushed onto the council for adoption, or return to subcommittee if everybody shouts and brings their pitchforks to the bar and say we got it wrong. But we'll see what happens.
Okay. Thank you for that, Brian. Anything further to come before the subcommittee at this time? All right, then I'll go ahead and say that we're done and for the day, and look forward to hearing from you and seeing you guys